Hello, hello, hello. It's Stephanie here. Welcome back to the Rent to Rent Success podcast. We are here on episode 134, a corker of an episode for you today. I am here with Mariam Raza. Mariam has a legal consultancy which helps landlords and letting agents when things go wrong. And Mariam's going to be dropping some gold dust today about the steps that you can take to protect yourself from things going wrong and to help you run your rental business so much more smoothly. So thank you so much for joining us today, Mariam, and welcome to the show.
Yeah, thank you for having me.
So, as we were just saying before we started rolling, you are a founder of Housing Sage, the legal consultancy to help landlords and letting agents. But I would love to know your story and how you got into this work.
Yeah, so I completely fell into housing law by accident. So I applied for a job to do housing law for a bit after qualifying and doing my law degree, and then just fell into housing law that way. So I qualified, and I've predominantly for the past 6 years done tenant work. I've trained landlords and I've trained predominantly social landlords, but a lot of my work has always been tenant focused. So I've always been on the other side when things go wrong. So last year I started Housing Sage, which is a training and consultancy firm. So I predominantly now work with landlords and letting agents. I use that experience of the past 6 years where I've been on the other side to now advise of, okay, how can we prepare for things? How can we avoid, common pitfalls, common mistakes? And now I'm predominantly focusing on the Renting Homes Act. So I'm based in Wales. I train predominantly Welsh social private landlords and letting agencies. And we've got a new piece of legislation that's due to come into force at the end of the year. So a lot of my work at the moment is getting landlords up and ready for that. So I've got a wide range of experience from both sides. But yeah, currently I'm using that in terms of training landlords and letting agencies.
So that's fabulous for any landlords, letting agents in Wales wanting to prepare for that new legislation. As we were just saying, we are based in Wales as well, so we will have the new legislation here. But what I wanted to say is that you're also an expert, Mariam, in English law, because the majority of our listeners will be in England rather than Wales. And I know that what you're going to talk about today will really apply to them. So I just wanted to point that out. It's not just for Wales, what Mariam's going to talk about today. It's also applicable to England. So where we're going to start off today is the biggest things that can go wrong. This is what everyone wants to know about. So let's start there, Mariam. What are the main things that you see going wrong for landlords?
So I think the main issue, and it all starts with this slow relationship breakdown between a landlord and tenant. And so what I would always advise landlords and tenants is to always have that open and frank conversation. So whether it's with tenants and it's unable to pay rent, or whether it's whatever it is, to have first that open conversation, have that mediation going, because it can negate a lot of court costs and a lot of other aggro in the long run. So having kind of an honest and frank conversation, or at least trying to have that honest and frank conversation. It's sometimes difficult. You're dealing, I think renting is a business where you're dealing with human beings, and you have a range of different human beings that you meet. So the first would be to kind of look at having an open and honest relationship with your tenant, to just be like, in terms of job loss or things, because that really then ties into the common issues that you see, which is rent arrears, disrepair, and antisocial behaviour. I think those are the three main issues, the three main cruxes that then lead to that deterioration of that relationship. So I'll talk about each one separately. So rent arrears is a big one, and it's often something that landlords that are either thinking about, or people that are thinking about becoming a landlord, or people that are already a landlord. It's a real fear. I mean, we had COVID, we've had, the cost of living increase rise. And so for a lot of people that are thinking about getting into this and are planning for this, a common concern for them is, okay, look, what if I don't get my rent for 6 months? What if I don't get, how am I going to be able to manage that and afford that, especially if I'm doing it as something that is passive income or as a second income? So there are certain measures that you can take. So it very much depends on who your tenants are. So I know that there's a lot of misconceptions about, well, do I have a professional tenant or do I have tenants that are on benefits? Which one is better to have? So, either one. With professionals, there's that sort of immediate that you can charge a higher rate because somebody that is on benefits will only be allowed what is referred to as the local housing allowance. So they'll be quite limited in terms of the rent that they can pay. But often a misconception is, well, if I get somebody that's in on benefits, then they're not going to pay their rent. But actually, there are more mechanisms that you can protect yourself against if somebody is on benefits and they're your tenant than somebody that is a professional that is working. So if somebody falls into rent arrears and they are on benefits, you can actually apply to have their housing element or the housing element of universal credit, or if they're getting housing benefit paid directly to you as the landlord. So you would write to the to DWP or the housing benefit to say this person is in predominantly 8 weeks worth of rent arrears. This is the rent statement. I would like for that rent to be paid directly to me. Alongside that, then you can also, if they are already in arrears, that only covers, that you're going to get the rent guaranteed for those coming months. But you can also ask for a deduction to be taken from their personal element. And so what that then does is it covers the ongoing rent, and then a proportion is paid directly from that person's benefits to pay off any rent arrears that they have. So that is often a misconception that people have, is that, well, if I'm accounting for renting out, then I'm going to completely disregard people that are on benefits. But actually, there are a lot more safety mechanisms to prevent that if that happens. The other things then to bear in mind when it comes to rent arrears is that, if things go wrong, what we always advise is that you first write to the tenant, try and find out what's going on. Is it because of a job loss? Is it because of an illness? What is the reason that they've now suddenly stopped paying rent? And then look at trying to negotiate, can we agree a payment plan, or can we agree something? So if somebody has had a period of a couple of weeks where, they were in between jobs or something happened, a large life expense, but now they're in a position where actually they're going to continue to pay the rent and they'll agree to pay a proportion off the rent arrears as well. Try and negotiate with them, because that will then help you in the long run, especially if then you're issuing a notice and going down the court proceedings route. If you have tried to negotiate in the early stages, that's really going to work in your favor. So the element would be to try and negotiate with them, see if there's any assistance that can be provided. The local authority, this again is something that people aren't aware of, that if somebody has lost their job, if they're going through a particularly difficult time, they can go to their local authority, they can go to their local council and ask for assistance from what is referred to as the Homelessness Prevention Fund. So it's a fund there that is used to prevent homelessness. So if somebody goes and says, actually, my landlord is threatening to evict me because I'm in X amount of rent arrears, I need some assistance, I need some help. I've worked with local councils that have either paid off lump sums, so we're talking about 2,000, 3,000 lump sum payments, some that have paid a lump sum and then agreed to pay sort of a monthly amount. So there's really a lot that can be done, as opposed to just looking at going down the legal proceedings route, which is more costly and doesn't always result in you getting your money anyway. If you get the local council involved, they might assist with that homelessness prevention fund, and they might assist with reducing those arrears or trying to figure out a way of managing those arrears. So a lot of local authorities also have something that's called the rent rescue scheme. So what that means is that they'll look at that person, they'll assess their income, and then they'll intervene in terms of a rent rescue, and that often includes paying off arrears in bulk and also making sure that that person, if they have lost their job, then are they on the correct benefits, so that they got the correct income to then maintain that rental liability going forward. So really look at negotiating, really telling them to go to their local council to kind of get that in that information and that help, because that could assist in the long run of them sustaining that tenancy for that period of time, whether that's where that particular difficulty is happening, and then it gets better going forward. However, there are some instances where you have a tenant that just is not paying rent. They won't go for any assistance, they won't go anywhere for any help, and then you're kind of in a period where months and months have gone by and there's no recourse to, or there's no result or resolution to what's going on. So in those instances, it would be, okay, you'd have to look at potentially issuing a notice. So when you're looking at issuing a notice, there are two schools of thought in terms of what landlords want to do. Some of them just want the tenant out and then want to kind of redo the property, relet it out quite quickly, and then save their money that way. Some landlords actually want their money, and there are a couple of ways that you can do that. So I'll do the one that is for rent, the notice that is for rent arrears, and then I'll do the notice that is basically referred to as a no-fault method of eviction. So a Section 8 notice.
Yes, Section 8, yes.
Yeah, so a Section 8 notice is used when somebody is in rent arrears. And so a Section 8 notice is just the statutory notice that you serve, and then what type of notice and how much time you give in terms of the notice depends on what grounds you're using. So the Section 8 notice is a statutory form. You can find an English version and a Welsh version online quite easily, free of charge. And then you basically, within that Section 8 notice, have to put what grounds you're relying on. And the grounds vary depending on what issue is at hand. So ground 8 is what is referred to as a mandatory ground, and that is if somebody is in 2 months or more worth of rent arrears. And when I say mandatory ground, what that basically means is that if the person at the time of the serving the notice, or the tenant, the time of serving the notice, and at the time of the court hearing is in 2 months or more worth of rent arrears, the judge has no option but to grant an outright possession order. The other then two options that you can use for rent arrears are grounds 10 and 11, and that is if somebody is in some rent arrears, so there isn't that 2-month caveat, or if somebody has been persistently late in paying their rent. 10 and 11 are discretionary grounds, and what that basically means is that if you choose to serve a notice on the discretionary grounds, then when you go to court, the judge can give the tenant one last opportunity and say, actually, I'm going to grant an order for possession, but I'm going to suspend it provided that the tenant pays the full rent plus an amount towards the arrears. So this is a reason sometimes why some landlords don't opt for it, because they're already at the point where actually they just want the property back, or they just want the full sum. So and some landlords will use a mixture of the mandatory and the discretionary grounds. So the mandatory grounds, sometimes tenants will get the arrears below 2 months, so then you can't use the mandatory ground, but then you can use the discretionary ground. So this option is really if the landlord still wants to continue to keep the tenant in the property, but wants an extra legal safety mechanism to ensure that they're getting their rent and that they're getting an amount towards the arrears. Once a suspended possession order is made, if the tenant then breaches that, then the landlord would apply for a warrant of eviction. The kind of, again, the downsides to that is that if a tenant then can establish that they are a change in circumstances, then they can apply to suspend that warrant of eviction and say, I've got a new payment plan now, I lost my job or something happened. So that method, I think, is really for if you intend to keep the tenant in the property, but you just want another sort of safety mechanism to ensure that you're getting your rent and you're getting an amount towards your arrears. So that, in a nutshell, is Section 8. And I'll talk about court costs and I'll talk about that element of it separately. So that is the Section 8 claim. So that is if you want to go down the basis of the tenant is at fault, it's as a result of rent arrears, whether that's 2 months or whether that's because they've been persistently late, or that there are some rent arrears, and then there's that distinction between mandatory and discretionary. A Section 21 notice then, which is quite widely and commonly known as a no-fault method of eviction, can be used even if there is fault. The reason why a lot of landlords use it when, even if there is fault, is because it's just a lot easier. You don't have to prove that someone is in rent arrears. You don't have to submit a rent statement. It's just, I just want the property back, and there's no reasoning. You don't have to give any reason as to why you want the property back. You just want the property back. But in some instances, landlords will use it because it's just a lot easier and it's just a lot simpler to use. So in those instances, there are two ways that you can get possession on a Section 21 notice. So it's a 2-month notice. Again, there's no fault that you are putting there on the basis of the client. or on the basis of the tenant. But when it comes to issuing possession proceedings, you've got two routes. You've got the accelerated route and you've got a standard route. So an accelerated route is you just want possession of the property. You don't care about the rent arrears, you just want the property back. Because with the accelerated route, it's quicker, but you can't ask for a money judgment for the arrears. With the standard route, it's a little bit slower because it's a standard route, but within that, even though you're saying that there isn't any fault, you can also include a claim for outstanding rent arrears. So again, that option very much depends on, I've seen landlords that are just like, to be honest, I don't, that's not really my concern. All I want is the property back. So they'll go and they'll opt for the accelerated route, or some landlords will include that within a standard claim. If you're a landlord that wants the property back and wants to use the accelerated claim, you can do that and get the property back and then issue a separate money claim for the outstanding rent arrears. So some landlords I've seen do that. So they will issue a separate money claim to get the money element back. So from a possession point of view, their kind of focus is just to get the property back.
And in your experience, is the accelerated route in actual fact any faster?
It is if you have a tenant that doesn't file a defence. So with the accelerated route, what happens is it's all done on the paperwork. So you can only use it if you've got a written tenancy agreement. And so you issue the claim and then it goes to a judge, and within the judge's chambers, they look at all of the paperwork and then they can grant a possession order. The only way that you delay that is if, so when you issue a claim, a defence form is sent to the tenant. If they then raise a defence, or if the judge, when they're looking at the paperwork, is like, actually, you haven't included all of the paperwork, or actually, I don't think this is quite right, and then lists it for a hearing, that is what makes it slow. The element that is making it slower is the listing of the hearing. That's why standard claim is also a little bit slower, because you're waiting for the court calendar and listing a hearing. But if you've got a tenant that doesn't respond, and if your paperwork is all in order, it actually works out to be, in my experience, a lot quicker than the standard claim, just because you're not waiting for the court to schedule a court hearing date, and then everyone's attending the hearing date. And then, it's also a lot easier if you are somebody that is sort of geographically a little bit further away, so you don't have to then come and attend a hearing. The only time you would, again, is if the judge, notices any errors in your paperwork, or if the tenant raises a defence.
Okay, so you've talked to us about the rent arrears, disrepair, non-payment of rent, and you've discussed the Section 8 eviction and the Section 21 eviction.
Yeah.
Now, I was interested earlier because when people come to you, when landlords come to you, you've noticed some biggest mistakes that people make. And I'd love to go into that, because these are the things that if you listen to these things that Mariam's just about to tell you, you can really protect yourself. And there are some of the things that we go over in the Rent to Rent Kickstarter program, so that everything is set up correctly, so that if you do need to evict anybody, you're all set. So Mariam, over to you for the biggest mistakes that people make.
Yeah, and they're not just big mistakes in terms of evicting someone. They can really cause a lot of stress to landlords. I've represented and I've been on the other side where landlords have fallen into these mistakes, and the amount of court costs and stress and time that then goes in when you don't account for these very small basic things that you kind of overlook is just so. I'll start off with deposits. So the biggest issue that I still see are landlords not protecting deposits. So the deposit protection rules have been enforced since 2007. And essentially what that means is that when you receive a deposit from a tenant, you have to protect it within 30 days, and you have to serve what is referred to as prescribed information on them. So when you go into the portal to protect a deposit, they will give you a booklet that is referenced as prescribed information, and you have to serve that prescribed information. So the biggest issue that I see is that sometimes people don't protect the deposit at all. Either they've forgotten. I've had a landlord that I recently finished a case on who just completely forgot. And unfortunately, completely forgetting or it being an oversight is not a defence that can be raised. So for her, the issue that she had is that she managed to evict the tenant. She protected the deposit and then evicted the tenant, but the tenant then still issued a money claim against her. And I'll go into why the tenant was able to do that. So it's really important that you not only protect the deposit, but you also serve the prescribed information. Another issue that I see people doing is they'll protect the deposit, but they won't serve the prescribed information. And the law is clear on that you have to do both elements of it in order to comply.
Mariam, what counts as evidence of serving the prescribed information?
So a lot of people send information via email. I would always recommend that if you are sending that via post, so if you've got somebody that prefers to be sent it via post, to keep a certificate of postage and just keep it in the folder or scan it and keep it as an online reference to show that you served that prescribed information on the tenant, because the burden is on you as the landlord to show that you've served that prescribed information. So if you're either a new landlord or if you are somebody that has protected or served the prescribed information, I would just ensure that you've got the information, because a lot of the times when you are sort of signing up for a property, there's so much paperwork involved, and the tenant also gets a lot of paperwork, that sometimes when you ask the question of will you serve prescribed information by your landlord, their immediate reaction might be no, but actually when they look through their paperwork, they have been served the prescribed information. So what I would say is to send it via email. Currently now, a lot of sign up for tenancies are done via email anyway. So it's just a lot easier to show, look, this was the attachment and this was sent to the tenant. The other thing would be then to send it via post, and then to keep a certificate of postage, and just to keep that on file to show that the prescribed information was sent to the tenant.
And I just want to point out here, if you are in the Kickstarter program, then part of our check-in checklist, you'll put your prescribed information into the tenant's portal on the property management software that they have access to. But also, when you check the tenant in, one of the things that they agree to is that they have received the prescribed information, which you can also show them in their app on their phone at that time.
Yeah.
And so all of the processes that are there for you within Kickstarter are set out so that you are protected in the things that Mariam is talking about, because you do need to be able to evidence. You need to not only give the prescribed information, but also be able to evidence that you have done so.
A lot of what I'm talking about are referred to as technical offences, and a lot of them are basically what you can refer to as like admin error. And that portal sounds ideal in terms of being able to evidence that and to show that they've done that. And then you've got also the further measure of the tenant agreeing to something, to saying that I have been given that prescribed information. So that is ideal. You can also, I've seen some landlords, get a document to sign that the people have referred, if they're more, old school and prefer to do that and don't have a portal to allow them to do that. But yeah, that's one of the issues. And the reason why it's so important that you do both is because the Housing Act 2004 will, if you don't do both of those things, then the tenant can be eligible for up to three times the amount in compensation of the deposit. So say, for example, their deposit is £500. If you don't protect it and you can't evidence that you've served the prescribed information on them within that 30-day period, then they can issue a money claim and ask for compensation. And what I'm seeing an increase of, you just have to go on normal websites to see, Google, that there are companies that are actually really plowing sort of on a no-win, no-fee basis deposit protection failure claims. So I've never seen that recently, but in the last, I would say about 2 years, I've seen a real increase in certain lawyers taking those cases on a no-win, no-fee basis. So it's really, really important from a financial point of view, firstly, because then you might be liable to pay the tenant compensation. The other reason why it's really important as well is because if you don't do that, and if you're not able to evidence that, you can't serve a valid Section 21 notice. And so that's really important as well. So if things go wrong and then you want to serve a Section 21, and it happens all the time that a landlord prior to coming to see me has served a section. So, serving a Section 21 notice, like I said, you can get a pro forma template off the internet, serve it, and then they come to me when it comes to issuing possession proceedings. And then when I'm looking through everything, you haven't protected the deposit. And if you haven't protected the deposit, you either have to give the deposit back, or you've got to protect the deposit and save the prescribed information, at least in Wales, and then start the whole process again of giving them another 2 months notice. Because once you do that, that doesn't make the notice that you've served valid. You then have to serve a fresh Section 21 notice. So something that was supposed to take 2 months is now going to take 4 months. And that's really where people lose out on time. And if somebody is doing it on the basis of rent arrears and doesn't want to go down the fault bit, that's another 4 months that you're not going to get rent. So that is one of the main issues that I see people doing, is not protecting the deposit correctly, or doing one and then not doing the other, which is also evidencing that they've saved the prescribed information. The other thing in terms of HMOs, so you have to have a HMO license in order to operate a HMO. I've dealt with some cases where a landlord hasn't had a HMO license. So if you are somebody that has made an application for a HMO license, during that period of determination, you can serve a valid Section 21 notice. What I've seen, though, is where people have created informal HMOs, haven't gone through the correct channels of correctly licensing it, even getting in contact with the local council to make the application, and then they go and then they look to serve a notice, and then that would invalidate or make a Section 21 notice invalid. The other issues then is, during COVID, we had sort of an increase in notice periods. So there was a moratorium, which effectively meant that you couldn't be evicted during that kind of first phase of the pandemic. And then what also happened is that Welsh Government and in England, they changed the notice period. So they went from 2 months to 3 months to 6 months. And now they're back to their original so in Wales, they're back to their original 2 month notice. So it's also making sure that if you serve a Section 21 notice, and if you've served it some time ago and then you've not acted on it, when you served it, were you giving the correct notice period? Were you giving the correct notice? I think those are the other issues that I see are predominantly to do with Wales. So if you are somebody that has a property in Wales, Rent Smart Wales is a big one, where people don't correctly register and license with Rent Smart Wales. And I think that is the bulk of the issues that I'm having with landlords currently, is where they've registered and they're not licensed, or they had a letting agent that had a license before and then they don't anymore, and then they go to serve a Section 21 notice. So in Wales, you have to be registered, and whoever is carrying out the management functions like collection of rent, all of those things, they are the ones that have to have the license. So whether that's a letting agent, whether that's a family member, or whether that's the landlord themselves, they have to have the license in order to do that. But a lot of the times you're having landlords that have either done one and not the other, and then it only comes to light when they want to serve a Section 21 notice that they're not correctly registered and licensed. So yeah, I think those are the main issues: notice periods, deposits. If you're in Wales, if you're in England, there are additional things. So if you, in terms of gas safety certificate, so you have to have a gas safety certificate in place, otherwise that can make a Section 21 notice invalid. So there are additional factors in England. So because we have devolved powers in Wales, we're very separate now in terms of how housing law is acted. But if you're somebody that has properties on both sides of the border, then you need to look at, okay, what are the rules in Wales? What are the rules in England? And then comply with those, especially when I think because Section 21 notice is a no-fault method of eviction, there are a lot more sort of precursors to that to ensure that you're complying with everything before serving it. So that is usually the one where people get the most tripped up, is the Section 21 notice.
That is so good to know. And you talked to us about a ground for a Section 8 eviction that maybe people don't know about and maybe people haven't been using. So I'd love it if you could talk about that.
Yeah. So with Ground 8, like I said, the majority of people only really know of it when it comes to rent arrears, and some private landlords have used it when it comes to antisocial behaviour. But there is a ground 12, which is any clause of the tenancy agreement has been broken, and that is, and within a tenancy agreement, you'll usually have that the tenant is supposed to use the property in a correct manner. You know, there's general fair wear and tear, but they're not meant to do anything that then further worsens the property conditions. So you can use ground 12 for other breaches. So if you are particularly concerned about the way that the tenant is living in the property, the impact on the property, if they are particularly doing something that is having an impact on the property. There's also another ground if you are renting out a property that is furnished, and then there's deliberate damage to the furniture. There's some more information that you can go onto the website, onto housingsage.com, and get some free information about that, and it goes through all of the grounds. But ground 12 is this sort of generic ground that can be used for any real breach of the tenancy. The only difficulty, again, with those grounds is that they are discretionary grounds. So you've then got to get over the threshold that the damage to the property is to such an extent that it would warrant the tenant being evicted. And if you've got a judge that says actually it isn't, then you might end up with either no order at all, or you might end up with a suspended possession order where actually the property, there are conditions that the tenant has to do XYZ in order to keep the property in a good condition, or they have to do XYZ in order to rectify the damage that they've done. So the only difficulty with them is they are discretionary grounds like 10 and 11 for rent arrears. So again, those options are available. They have shorter notice periods than a Section 21 notice, but the only, I would say, caveat to that is that there might then be a suspended order made with a positive requirement that the tenant has to do XYZ to keep the property then in a good condition.
So again, another reason why people might towards the Section 21. And I suppose I should just point out one of the things that I observe is that these issues with eviction tend to be less, in our experience, in HMO management than in single let management. And because of some of the complexities, what we found is, although we do serve the notice, we tend to agree a voluntary agreement with the person to relinquish their tenancy because it can be a lot swifter. But whatever your circumstance, if you want to talk through what possibilities are for you, to see if any obstacles are in your place, or just to fully understand what the context is, then you can reach out to Mariam at housingsage.com. So that's housing, SAGE.com, and you'll be able to book some time with Mariam from there. So, Mariam, as we draw to a close today, is there a message that you'd like to leave people with about this?
I think, we've talked about this before, that people only ever come to me when something goes wrong. But I would really say to really familiarise yourself with all of the information that's available. I think in England, it's slightly more complicated because you've got lots of different pieces of legislation. But all of the information is available. It's readily available. It's there. And it really will save you in the long run to have a look. Okay, what do I need to do? What do I need to comply with? Create a checklist. Ensure that you're doing all of that, so that if you do need my assistance, or if you do need anyone's help, and if you do have to go down the eviction route, then all of your ducks are effectively in a row when it comes to that. Again, in Wales as well, that's the whole idea why we're having renting homes, is so that we're going to have one piece of legislation that people can go to and look at, and then that will be your resource point. So I would often say, I wouldn't leave it always to, okay, I'm going to go and get legal advice when something goes wrong, to kind of preempt that and kind of look at, okay, what safety measures can I put in place? What can I inform myself of first and foremost, so that if this did happen, or if something, did go wrong, then at least I know that I can do XYZ. So information and knowledge, as corny as it sounds, is always power. And it really is, because it will put you in a position where you'll know very clearly what happens, what needs to be done. And then you can account for that when you're looking at taking on a further property, or when you're looking at a business plan, or whatever you're doing. You can account for all of that and prepare for that effectively.
I love that. And Mariam, what you're saying essentially is prevention is better than cure. And Mariam, you can help with both.
Yeah.
So do go over there. You'll have seen it if you were watching on the website. We did have Mariam's website up just a moment ago, housingsage.com. And also, if you're just at the beginning starting to think about getting started in rent to rent, I know this sounds super complicated, but we have broken it down step by step about how to be compliant the simple way, and it's all in the Rent to Rent Success Guide and Masterclass at renttoRentSuccess.com/guide, GUIDE. It's a fantastic free resource for you. And if you're already within our Kickstarter mentorship, we've got exactly all the steps to do as you onboard your tenant so that you are already protected should the worst happen. But mainly because of those protections and the way that you onboard the tenants, the way you choose the properties, you're much less likely to have the problems that we've been discussing here today. So I want to thank you, Mariam Raza, for coming in and talking to us today. It's been an absolute delight to have you on the show, and I know that people will have found that super useful.
No, thank you for having me.
Yes, and it's lovely to have a fellow person from Wales and exactly in Newport where we are. So housingsage.com if you want more Mariam. So thank you so much for joining us today, for being here, for listening, for watching, and I'll see you all again next week. In the meantime, believe bigger, be bolder, be a game changer. See you next week. Bye for now.